An 8-1 Supreme Court ruling is still sending shockwaves through gun law, and most gun owners still do not understand how big it is, because this was not just about one violent defendant. It may shape who can be disarmed, how judges review gun laws, and what happens when police come looking for firearms at your home. Quick question before we continue. Are you subscribed? Because these legal shifts move fast, and missing one update can leave you guessing when your rights are on the line. Hit that button now. Here's why this matters so much. A lot of people heard the headline and thought, okay, that is just a domestic violence case. That does not affect me. That is the first big mistake. The Supreme Court used this case to explain how lower courts should read the Second Amendment after the Bruen decision. And once courts start changing that test, the next fight is not just about who can own a gun. It is also about when the government can take one and how officers can lawfully do it. That is where the Fourth Amendment starts to enter the picture. So if you care about your carry rights, your guns at home, or what happens during a police encounter, stay with me. Because the part most people are missing is the part that could affect you next. Here's what just happened. The case is United States versus Rahimi. The Supreme Court ruled 8-1 that the federal government can temporarily bar a person from having guns when that person is under a qualifying domestic violence protective order, and a court has found that person poses a real threat to someone else's safety. In plain English, the court said this: if a judge has already found that someone is a credible danger, that person can be disarmed for a limited time without breaking the Second Amendment. Now, let me explain why that mattered so much. Before this ruling, the Fifth Circuit had struck that law down. It said the government had not shown the right kind of historical support under Bruen. And Bruen, if you remember, told courts to look at America's history and tradition of gun regulation. That sounds simple, but lower courts have been all over the place. Some judges read Bruen very narrowly, others read it more broadly. That created chaos. Rahimi gave the Supreme Court a chance to step in, and the facts were ugly. Rahimi was under a protective order after an alleged assault on his girlfriend. After that, he was linked to several shootings. Police later got a warrant, searched his home, and found guns. He was then charged under the federal law that bars gun possession by people under certain domestic violence restraining orders. And this is where it gets interesting. The Supreme Court did not say, the government can disarm anyone it calls dangerous. That is not what happened. The court made the rule narrower than that. The majority said the key issue was a court finding of a credible threat. It also stressed that the disarmament was temporary, not permanent. That matters a lot. Justice Clarence Thomas was the lone dissenter. He argued the government had not shown a close enough match in early American history. But the other 8 justices said the government did not need a perfect historical twin. It only needed a good historical match in principle. And that little shift may be the biggest part of the whole ruling. Why? Because the court pointed to older laws that let officials act against people who threatened others. One type required a person to post a bond if they seemed likely to breach the peace. Another punished people for going armed in a threatening way. The court basically said, look, America has long had ways to respond when someone poses a clear danger. So the modern law did not have to be a copy and paste version from the 1700s. That is the part that shocked a lot of people. The ruling was not only about Rahimi, it was also about the method judges will use in future gun cases. And once the method changes, the battlefield changes with it. If this is helping you make sense of the chaos, imagine what my next video will do when I break down the exact words you should and should not say when police ask about a firearm. Subscribe now so you do not miss that one. Now let me break down why this matters for the Second Amendment far beyond this case. Most people think Rahimi only affects domestic abusers, but the truth is bigger. The court used Rahimi to tell lower courts not to demand some perfect museum piece match from 1791. The justices said, the Constitution is not frozen at muskets and sabers. That line matters. It means judges can look for similar principles, not exact copies. That gives governments more room to defend gun laws. But wait, there is something even more important. The court also refused to go as far as the government wanted. The government argued, in effect, the people who are not responsible can be disarmed. The court rejected that broad idea, and that is huge. Because responsible is a vague word. It can stretch fast. If the court had accepted that theory, the government would have had a much easier time defending all kinds of restrictions. So the ruling cuts both ways. On one side, it makes it easier for some gun laws to survive, because courts can use broader historical comparisons. On the other side, it blocks the government from using a mushy label like irresponsible to strip rights away. That is why this case is so important. It is not a total loss for gun rights. It is not a total win either. It is a reset. It redraws the map. Here is what most people get wrong. They think the court said accusations alone are enough. Not true. The opinion focused on an actual court order and a finding of a credible threat. That means process matters. Findings matter. Time limits matter. Those details are going to be the center of future cases, and future cases are already lining up. Courts are still fighting over gun bans for unlawful drug users. They are still fighting over gun bans for some nonviolent felons. They are still fighting over age limits in other categories. Rahimi does not answer all of those questions, but it gives judges a new lens. Some laws will now look stronger. Some will still be vulnerable. That is why people on both sides are still arguing. Have you ever wondered why one judge says a law is clearly constitutional, while another says it is not? This is why. The fight is often not about the final answer, it is about the test. Now, quick legal note, this is educational information, not legal advice. Always consult an attorney for your specific situation. Now here's the part nobody is talking about enough. Rahimi was a Second Amendment case. It was not a Fourth Amendment case, but it could still affect Fourth Amendment fights. Why? Because once the government says it can disarm certain people, the next question becomes very simple and very serious. How does the government actually get the guns? And that brings us to your home. Most people think if a judge can say you may not possess firearms, police can just show up, walk in, and take them. Not so fast. The Fourth Amendment still matters. That amendment protects you against unreasonable searches and seizures. In plain English, it limits when the government can search your home or take your property. Here is the key case you need to know. In Kenneally v. Strom, the Supreme Court unanimously said police do not get a free pass to enter a home and seize guns just because they say they are doing community caretaking. That phrase sounds harmless, but it was being used as a broad excuse. The court shut that down for homes. Here's a simple version of Kenneally. A man had a disturbing argument with his wife. Police later took him for a mental health evaluation. After he left, officers entered the home and seized his firearms. The Supreme Court said that kind of home entry could not be justified by some open-ended caretaking theory. In other words, the home is still special under the Fourth Amendment. But here is the crazy part. The court also made clear that real emergencies are different. If officers have an objectively reasonable basis to think someone is in immediate danger, they may still be able to enter without waiting for a warrant. So the line is not never. The line is not whenever police want. That is why Rahimi and Kenneally together are such a big deal. Rahimi says some people can be temporarily disarmed after proper findings. Kenneally says officers still do not get a blank check to enter homes and seize firearms without following constitutional rules. Put those together and you get the next major legal battlefield. Not just who can be disarmed, but what process the government must use to do it. Hey, 73% of people watching channels like this are not subscribed. Do not be part of that group. Join the people who stay ahead. Instead of hearing about them after the damage is done, click subscribe right now. Let me show you how this could play out. Here's a hypothetical example to explain this. Imagine a man gets served with a protective order after a messy breakup. He tells himself, "This is civil court stuff. I will deal with it later." Big mistake. If that order includes the right findings, his gun rights may change immediately, even before any criminal conviction. That is the Second Amendment side. Now imagine the next step. Officers want the guns. Can they kick in the door that night and grab them? Not automatically. If they have consent, that is one thing. If they have a warrant, that is another. If there is a true emergency, that may also change things. But without those factors, the Fourth Amendment still puts limits on what they can do inside the home. Here is another hypothetical. Imagine you are at a traffic stop. You lawfully tell the officer you have a firearm in the car, or maybe the officer sees it. Most people think that alone means your Fourth Amendment rights vanish. Wrong. Having a gun does not erase the Constitution. Police still need a lawful basis for a search. Now, if you are already under a qualifying order that makes possession illegal, that changes the situation fast. But the point is simple. Gun ownership and search power are not the same question. This is the mistake I see over and over. People confuse possession rules with search rules. They are related, but they are not identical. The government may have a stronger case that you cannot legally possess a gun in one moment while still needing to follow strict rules before searching your home in the next moment. And here is the warning. Do not ignore civil hearings. Do not assume I was never convicted. Ends the story. Do not assume they cannot come in without a warrant means I can keep the gun no matter what. And do not assume the police said it was for safety automatically makes a seizure legal. Every one of those assumptions can get someone into serious trouble. When I found this out, one thing stood out immediately. The pressure point is no longer just the gun law itself. The pressure point is procedure. What did the order say? What findings did the judge make? How long does the order last? Was there notice? Was there a chance to be heard? Did officers get consent? Did they have a warrant? Was there an actual emergency? Those details are going to decide cases. Now, this is where it gets even more interesting. Red flag laws, also called extreme risk protection order laws, are likely to keep driving this fight. These laws usually involve a court order that can restrict gun access based on claims that someone is a danger to themselves or others. Supporters say they save lives. Critics say they can be abused and can short-circuit due process. Both sides know the same truth. These laws sit right at the line where the Second and Fourth Amendments meet. Rahimi may help governments defend some of those laws on the gun rights side, especially when there are clear findings of danger in limited time periods. But Caniglia reminds everyone that entering a home and seizing property still raises a separate constitutional problem. So do not be surprised if the next big cases are not only about gun rights. They will also be about how the state carries out that loss. Here is what you should take away from all of this. First, the Supreme Court did not erase the Second Amendment. Second, it did say dangerousness findings can justify temporary disarmament in at least some cases. Third, it signaled that lower courts should use a practical history test, not a rigid one. And fourth, none of that means the Fourth Amendment is dead. Home entry and a gun seizure still face constitutional limits. That is why this ruling could reshape both amendments at once. One amendment asks, can the government bar possession here? The other asks, can the government search and seize like this? Those are different questions. But in real life, they collide fast. And if you are a gun owner, there is one more lesson. The people who stay safest are not always the loudest people online. They are the people who understand the process before they are standing in it. They know the difference between a criminal charge and a civil order. They know the difference between consent and compliance. They know when to stay quiet and call a lawyer. This legal landscape can shift again the moment the next major case drops. Subscribe now, because my next video will break down the practical steps gun owners should take the second a protective order, welfare check, or police contact occurs. So here's the bottom line. The Supreme Court's 8-1 ruling in Rahimi changed the way courts will analyze gun cases. And while Rahimi itself was a Second Amendment case, its ripple effects could shape the next wave of fights over gun seizures, red flag orders, and police entry into the home. If you care about your rights, do not wait until a judge, an officer, or a court paper forces you to learn this the hard way. Subscribe, stay informed, and stay one step ahead. And always remember, this video is general education, not personal legal advice. Laws vary by state, facts matter, and if this touches your life, talk to a qualified attorney right away.